Good morning. I have the privilege of going over what we discussed yesterday. I was struck by Chief Justice Rabner's opening remarks and how he used the metaphor of an old house in need of repair to open our event. Our judiciary is almost 300 years old, and we have made both major and minor renovations over that time. All of you should be aware of the extraordinary renovations that we undertook with the passage of the 1947 Constitution. But what we sometimes fail to recognize is this ongoing quest by successive Chief Justices and members of our Supreme Court to modernize our metaphorical justice complex. I've had the pleasure over the last almost 15 years of working with the current architects and contractors responsible for the maintenance of this metaphorical building. Now, the renovation strategy has remained the same despite the issue or challenge. When necessary, the approach is to overhaul, redesign, and transform both the interior and exterior of our building, installing additional foundations and support to advance justice, fairness, and equality. Now, I must tell you that in some ways, the members of our court are like working with my wife. There are constant renovations that have occurred over the last 15 years. I can regale you with all of the reforms and renovations, whether it's new windows, new basements, new HVAC systems that have occurred. I just want to give you a partial list of the kinds of improvements that we've made working with all the assignment judges here, all the administrative leaders here, and most importantly, with members of the bar to advance that thing called justice. 2008, we were dealing with a foreclosure crisis. We created a foreclosure task force to improve our foreclosure process. Municipal court reform, dealing with the challenges of a limited jurisdiction court. Guardianships, understanding the dynamics of people who are at vulnerable stages of their life. Most recently today, landlord-tenant reform, which is a major crisis that we see facing. Juvenile justice reform, complex business reform, expungement reform, mental health initiative, criminal justice reform, and an action plan to ensure equal justice for all. Now, some of these challenges, some of these initiatives were being undertaken, with all due respect to my boss, at the same time where we're dealing with others. So you see the dynamic, the commitment of the 7 people here to advance that arc that Dr. King described. And I'll also say there's one other thing that we've had to manage in terms of maintaining our house during the last 18 months or so, is how do you keep the doors of the courthouse open, both virtually and physically, during the midst of an extraordinary pandemic? And I will tell you that it's been my pleasure to work with some dedicated and talented members of the court to live up to that mission. But from this conference, the Chief Justice envisioned the development of a new architectural rendering that will remove and replace the discriminatory and faulty floorboards of our house through a collaborative and constructive examination of all aspects of jury selection. The consultants would be comprised of stakeholders from both within and beyond the legal community, as well as judges, business community partners, and average citizens to help reform and redesign our plan. We were also had the pleasure of hearing from Professor Eddie Glaude, who provided inspirational opening remarks on the disconnection between our perceptions of our house as viewed from the lens of our national ideas and aspirations. He juxtaposed of becoming and maintaining a multiracial democracy against our historic and current reality of systemic racism and discrimination. He noted the intrinsic difficulty of attempting to reconcile that is what we say we want to be with the deliberate actions that have caused us to become what we are. Dr. Glaude implored all of us, judges, attorneys, and other stakeholders who are participating in this conversation to engage in an ongoing analysis to move beyond the comfort of false narratives and to confront the institutional barriers that continue to prevent us from realizing the aspirations of a true democracy and a true justice system. Next, our first panel explored jury voir dire by focusing on three perspectives. Judge Lisa and assignment Judge Thornton, respectively, discussed the history and current design configuration of our jury selection process. Public Defender Kokora offered a new set of drawings, popular in many jurisdictions with many different forms, known as ACVD, or Attorney-Conducted Voir Dire. In the second panel, the conference participants heard from two outside experts or continuing consultants, those contractors who have been working closely with the judiciary from some time. Professor Nina Chernoff focused on pre-reporting processes that affect jury diversity, highlighting both the best practices already implemented in New Jersey and others that should be explored. Dr. Mary Rose then reviewed an empirical analysis of a sample jury selection. Dr. Rose confirmed the loss of diversity mentioned by Professor Chernoff and explained that peremptory challenges were at a concerning level because they reduced or eliminated the remaining diversity in roughly 1/4 of the selections she examined. The third panel examined jury selection process not just from the perspective of the residents of our house, but from the vantage point of the visitors to the building. Howard Berchoff, assignment judge of Atlantic Cape May Visnich, explored his firsthand knowledge, his firsthand overview of the jury improvement initiatives over the past 40 years. He also spoke about the number of jurors called to report and to go to voir dire service, just in case attorneys use all of their available peremptory challenges. Will Snowden of the Jury Project and Greg Zeff of the NAACP New Jersey were another group of outside engineers and design builders who critique the national jury practices that reduce diversity by excluding people of color. Echoing Professor Chernoff and others, these panelists advocated for a re-examination of the permanent disqualifications for individuals convicted of felonies. Mr. Snowden and Mr. Zeff also emphasized the need for juror compensation to offset childcare and other costs so that more members of the community are able to serve. The closing panel, led by criminal presiding judge Ed McBride and Passaic County prosecutor Carmelita Valdez, reviewed 3 new supports to this renovation. Those supports would help jurors and attorneys navigate the corridors of this new building. They reviewed recent Supreme Court initiatives to bolster jury education about implicit bias, including a newer jury impartiality video, additional voir dire questions, and enhancements to existing jury charges. The speakers, from my perspective, returned to a designed considerations in the following areas. Number 1, might there be a better way to involve attorneys in the questioning of jurors? Number 2, could improved juror compensation lead to greater community involvement and more diverse jurors? Number 3, based upon the data, should the felony disqualification be reduced to a limited duration or eliminated entirely? Number 4, how might the extraordinary number of peremptory challenges available in New Jersey, which is 2 to 3 times as large as any other jurisdiction, further reduce jury diversity? And finally, what steps can the judiciary and others undertake to support juror impartiality? But let me close with where we began through the words of Chief Justice Ravner. He noted that we are not involved in creating a simple set of blueprints, but we must begin the actual construction, the actual renovation of this project to remove the artificial discriminatory barriers to a true cross-representative and fair jury selection process. Thank you.